He's a pariah. We get it.
But, Your Honor,
Yeah.
it's clear to you, you've been in this case for how many years? I think if we take an extra 2 minutes in the course of the 5 months for Mr. DeGuerin to elicit that, we won't be causing undue delay. So,
All right, it's the 2 minutes added to lots of other 2 minutes. But, all right, you can have 2 minutes.
I can't say my name in 2 minutes, so it's going to be a little bit longer than 2 minutes.
Oh, well, yeah, the offer is 2 minutes, so I'll go with 2 minutes.
Well, he made the offer, I didn't.
Well, you don't have to say your name, do you?
Dick, he doesn't mean, I didn't mean it literally,
Yeah,
and the
no.
judge understands that. Okay.
2 lawyer minutes, that's fine.
There you go. Now we're talking.
I get it. All right, now, what is it about? Is that it? Is that the whole thing?
Well, there was some other issues that Mr. DeGuerin wanted to elicit about about Jarecki and the Jinx, which we thought we would address with you when you discussed the jury question with us. We don't have to do it on the record.
Okay, and we'll put it on the record later, depending on it, if we have to. Now, we have a jury. I want to talk to you about scheduling and a juror's availability. So let me adjourn. We'll put it on the record tomorrow morning if we need to. All right?
Okay.
Department.
Oh.
Yes. What?
Oh, you don't want to talk about the juror now.
I do in chambers.
Oh, in chambers, okay.
Yes.
Didn't
Okay.
understand.
Department 1 is adjourned.
All right, so the judge there rings the bell, and they are, in fact, now done for the day. I want to bring back in my guest, criminal defense attorney Adam Johnson. One of the things that was going on this afternoon is they were talking about the Morris Black situation. There was some arguments. The judge ultimately didn't allow the defense to bring in these prior bad acts of Morris, and they felt that it was enough for Durst to testify that it was a self-defense issue and that he was worried about this gun. He pulled a gun on him, and that was enough. And one of the things that bothers me about that is, the prosecution's trying to prove a number of murders. You got Kathy Durst, you have Morris Black, and then you have the one that actually at issue in this case, Susan Berman. And they're talking about Morris Black, but they're not allowed to give a full defense, even though the prosecution is trying to prove that he's guilty of a crime that he's actually already been acquitted of. I want to get your thoughts as a criminal defense attorney and that whole issue, the fact that there's going to be different rulings, there's going to be different opportunities for the defense to put forth the information that they want to put forth.
Yeah, it's historically the case that you don't aim to have trials within trials. There's a chance that the jury becomes confused and focuses on the wrong issues anytime you have a separate incident other than the one charged. But clearly, the decision has been made to allow for that trial in a sense within this trial. And it seems to me that if there's going to be that mini trial, it should allow for each party to present the evidence they want. So there's a full and fair airing of each of the side's evidence.
Yeah, I would have to agree. And that's one of the problems I have with the approach being taken by the prosecution and ultimately by the court in general. But this whole Morris Black thing, again, he gets an opportunity to tell his story. He was acquitted. It was a self-defense claim. They did a quick demonstration in the courtroom. They had a presentation on it as well. But one of the interesting things about that particular self-defense claim is that it still involves some awful details, right? Afterwards, he dismembers the body. Now, that jury seemed to be able to put that aside and acquit him of that crime. But now you have another instance, right, of odd behaviors, some questionable behaviors. When you begin to add all those together, it may sound very different to this jury than it did to the one in Galveston.
That's correct. And I think it was a remarkable thing that happened in the Texas jury trial. I'm not sure that would happen every time that case were placed before various juries throughout the states. And so it's definitely a concern in this case that you're going to have the prejudice prong of the balance tip over against the defendant.
Yeah, and that's the thing that concerns me about his testimony at this point. You start piling up all these coincidences. In your estimation, do you think the prosecution has done enough to get a conviction in this case? Again, it's been a long case, 44 days, lots of evidence, none of it direct, a lot of it all circumstantial. But as we know, many of these cases are built on circumstantial evidence.
They are, and there are people who will tell you that circumstantial evidence cases can be stronger at times than direct evidence cases when you have so many circumstances coming together in the direction of the proof that the prosecution is attempting to place before the jury. mindful of their burden, it still can be the case that in a circumstantial evidence case, it's even more damning given the totality of the circumstances than a case with direct evidence.
Yeah, and I think that may be the case in this one. All right, Adam, stand by. We're going to take a break right now. Coming up next, we're going to have a live report from Mandan, North Dakota. In case you missed it, our Chanley Painter will get you caught up on all that happened in court today. So keep it right here on Court TV. Hello and welcome back to Court TV Live. I'm Michael Ayala. They have wrapped up for the day out in California in the Jinx murder trial. So we're going to turn our eyes now to North Dakota, where we are in day 9 of the other big trial that Court TV is covering for you, North Dakota versus Chad Isaak. Now, chiropractor Chad Isaak is accused of shooting and stabbing to death 4 people at a property management company on April 1st of 2019. Today, the jury heard about DNA and blood evidence found at the scene and at the defendant's home and truck. Now, his defense team insists authorities zeroed in on the wrong man and botched the investigation of the crime. And several times today, they raised questions about how evidence was handled. Here's a look at some of the biggest moments from this afternoon's testimony.
We have everyone present, so we'll proceed with the trial this afternoon. The state may call its next witness.
The state would call Emily Hogue.
May examine.
Thank you, Judge. In this case, what type of analysis was requested?
For the items that I did the biological screening, it would be for DNA.
When we look at the items that were screened from Mr. Isaac's vehicle, item 14, that driver's side door jamb, what was the result from that?
Presumptively positive for human blood.
And the driver's third door latch, number 15, what was the result?
Presumptively positive for human blood.
Now, a number of the items that you outlined are from Dr. Isaac's residence, correct, that you had done presumptive testing on?
For blood, yes.
And there was no human blood detected on any of the clothing, correct?
Correct.
And there was no reddish-brown marks on the shoes, correct?
Correct.
So in this case, when you're testing for the hemotrace for the heme protein, that potentially could also be denatured or destroyed in the cleansing process?
Yes.
When we look at item 15, the swab of the driver's side third door black latch of Chad Isaac's vehicle, was a profile able to be developed from that vehicle swab?
No, there was not. The DNA from the vehicle swab, item 15, did not meet the laboratory's minimum quantitation threshold for amplification.
And then if we move on to item 16A, the piece of plastic swab from Mr. Isaac's vehicle latch of his third door, was a profile able to be developed from that piece of plastic swab?
Yes, there was. The major profile was a partial profile and matched the profile developed from the known sample from Chad Isaak at the loci developed.
So again, we have the driver's side third door latch of Chad Isaac's vehicle testing positive for human blood, is that right?
Yes, I believe it tested presumptively positive.
And there's more than one contributor at this location as well?
That's correct.
You said that the majority here matched Chad Isaak?
Yes, the major profile matched the profile developed for Mr. Isaak.
And the profile also correlates with Lois Cobb and Robert Faulkner?
Yes, that's correct.
In this case, was a connection made between some of the victims and the RJR vehicle?
Yes.
Was a connection also made between some of the victims and Chad Isaak?
Yes.
What specific area connected the victims and Chad Isaak?
The swabs from Mr. Isaac's vehicle, items 14 and 16A.
All right, it is time now for the debrief, where we get you caught up on all the biggest moments in court today. And for that, we turn to Court TV legal correspondent Chanley Painter, who joins us live from Mandan, North Dakota. Chanley, the jury heard a lot of testimony today about DNA from the crime scene, from the truck, from the defendant's home. But in the end, and we heard a little bit of it there at the end of that testimony, how much of that DNA was actually tying the defendant to the crime?
Well, today, Michael, late this afternoon, the jury heard about two big results that prosecutors and this expert say tie the victim's blood to the defendant's white Ford F-150, particularly on the driver's side door. They describe that Robert Faulkner, one of the victim's blood, and Lois Cobb's blood could not be excluded from that driver's side door jamb or a plastic latch from the truck door. And statistically, it would be highly unlikely, according to this expert, almost nearly impossible for that profile mixture to occur again in the population, saying the finding was greater than 1 in 482 billion. Sounds pretty strong to me. And in addition to the white Ford truck Isaac owned, the expert also tied the victims to the RJR truck that was stolen, the William Cobb's, the Cobb's work truck that was stolen from the crime scene and driven just a few yards away to Indigo Signworks. So they were able to also connect the victims to that part of the vehicle.
All right, now, Chanley, let's talk about Isaac himself. It has been 9 days, and surely this jury has gotten a really good look at him. They saw his booking photo where he has really an odd expression while being arrested for the killing of 4 people. You can look at it there. I mean, just, I don't know what to make of that. And we have all noted really some of his odd reactions in court, particularly during the medical examiner's testimony. Now, you're in the courtroom. How does he seem to be coming across in general to the court and to the jury?
Yeah, see that little motion right there? We just showed a little making a gun motion. That was probably the most standout nonverbal reaction we've seen from him. At one point, I thought he was going to stand up the other day or raise his hand to say something. You can tell he's wanting to say something, especially when he disagrees with whatever the witness is testifying to. And the jury can't help but notice they are directly across the courtroom from that table right there, so they can see him full face, full body, full reaction. Their line of sight is almost directly towards the defense table, as it would be. They'd have to turn their head to see the witness or the prosecution asking questions. So they really do have a front row seat to all of his nonverbal reactions, and he sometimes can seem a bit unemotional and detached. He carries in this huge green bag, and officers help him do this, but it's full of, I guess, his court documents. He'll have them stacked up there on the table in front of him. He'll take notes. Today he was leaning over, vigorously whispering at times to his attorneys, telling them certain things, and just, you have to notice it. It makes me wonder if this jury will actually hear from him, because he seems like he wants to say something, Michael.
Yeah, he definitely seems very much involved and oftentimes, like you said, disturbed by some of the things he's hearing. So what are we hearing about the defense's case, and what are the chances Isaac does take the stand?
Well, there is always a chance, of course, to hear from the defendant, but the defense did file a witness list, an exhibit list. They plan to put on a case, maybe a day or two worth of evidence, and it's the big theme, the takeaway from this witness list is the motive. Other people who would have motive to do away with the victims that were murdered at RJR Maintenance and Management, particularly the wife or the widow, Jackie Faulkner. Her husband was having an affair with Lisa Nelson. Lisa Nelson's name is on the defense witness list. There's a decree of divorce from Lisa Nelson and her ex-husband, who was allegedly violent. So again, we're even seeing that today on cross-examination from the defense of those investigators about how they zeroed in on Isaac at the exclusion of all of these other people they could have looked at. So that's what I think we can expect to be the main theme of the defense case when it does begin, which could be possibly Wednesday, Michael.
All right, now we're going to have to keep a close eye on how much latitude the court gives them in exploring some of those other folks. And finally, Chanley, what can we expect when court resumes tomorrow?
Well, we can expect this DNA expert to still be on the stand and expect a vigorous cross of this expert, because I'm sure the defense will try to point out all of the items that don't connect Isaac to the crime scene or to the victims in this case. Then we're also expecting to hear from more experts, a firearms expert, a trace evidence expert. Remember those orange fibers? We're going to hear from someone that will, according to the prosecution, tie those orange fibers possibly to the orange sweatshirt found at Isaac's home. So more testimony, expert testimony, coming for these jurors tomorrow as the prosecution really tries to connect forensically Chad Isaac to the crime.
Yeah, they certainly are doing that. All right, Chanley Painter, thank you so much for that report. Always appreciate your presence on the show. Right now, I want to bring back in criminal defense attorney Adam Johnson. And Adam, you know, it's been 9 days and we've heard tons of testimony. This was a passionate killing, a lot of emotion involved, but a lot of this testimony is dry. And what do you make? Is that a problem for the prosecution? I mean, we're getting expert after expert basically telling us things I would imagine, I guess, we need to hear. But I'm wondering if maybe this might be going too far afield here. They've put on a lot of evidence, a lot of strong evidence.
That's correct, and I think it's you know, a rule among lawyers not to bore a jury. I don't think it would tip the balance such that, you know, there's an acquittal for that reason. But yeah, it has been somewhat dry. That sometimes is the nature of criminal jury trials. I recall during the trial of Derek Chauvin, there were times where it was quite dry. There were multiple experts. But that's the necessity of proving a case up, especially when you have a case such as this where it's been so meticulously investigated from multiple angles and different kinds of science.
Yeah, I think the other side of that coin, too, is the fact that I think the prosecution realizes that one of the main arguments of the defense is that they botched this investigation. There were all kinds of problems with this investigation. They're not used to handling this volume of evidence, this type of case. What do you make of that particular defense?
I think in a case like this, it's not as strong. It can be countered during the course of the trial, and that's what's happening. The prosecution can say, well, they said this wasn't investigated correctly. Here you go. And we've seen that now for a number of days with the meticulous presentation of various kinds of evidence.
Yeah, and every time they question someone about chain of custody, they just come back and redirect and sort of make sure that the jury understands it was done with the proper way, according to proper procedure. We were looking there at Chad Isaac. What do you think about his chances of taking the stand? Is that something that might be needed in this case? Again, in looking, you know, we monitor these cases a lot on social media, and about 2 or 3 days ago, a lot of people were perhaps feeling like, well, I'm not so sure, but now most of them are saying the prosecution has a strong case. They believe this guy is guilty, don't see a way out for him. Is taking the stand the only way? Would you advise something like that?
It's difficult to say. Ultimately, the decision is his. It could be very harmful for his case as well. Once he's on the stand, he's on the stand. You don't get to say, sorry, I regret this and I want to get off now. You're on for as far as the prosecution wants you on, as long as the evidence is relevant and probative to their case. And so it's a huge risk. It's difficult to say whether he will, whether he should. I don't know.
Yeah, when you look at his mannerisms in court and some of his reactions, I don't know if he has that type of personality, but again, like you said, it's really up to him. Well, ultimately, he'll be the one deciding, and defense attorneys, you know, we're always loath to put them on the stand, so I'm not sure whether that'll take place, but we'll keep an eye on that. All right, Adam Johnson, stand by. We're going to take a quick break right now, and just ahead, we're going to take a look at that case of the 2 Georgia area basketball coaches who were facing murder charges in the death of a student athlete. You don't want to miss that. That is our talkback question as well. Do you think coaches should face murder charges when a student athlete dies during practice? I want you to go to Court TV's social media pages and let us know. We'll have your answers coming up, so keep it right here on Court TV. Hello and welcome back to Court TV Live. I'm Michael Ayala. 2 high school basketball coaches have been indicted on second-degree murder and other charges in the death of a student athlete. Imani Bell was a 16-year-old junior at a school in Clayton, Georgia. She was taking part in required conditioning drills for the girls' basketball team in August of 2019 when she collapsed. She would ultimately die later that day of heart-related cardiac arrest and kidney failure. Well, now a grand jury has indicted head coach LaRosa Walker-Ashacure and assistant coach Dwight Palmer on charges of second-degree murder and child cruelty. Now, the temperature on the day of the outdoor practice was in the high 90s, and the area was under a heat advisory. Now, the indictment reads that irrespective of malice, so malice is not required, the coaches did cause the death of Imani Bell while in the commission of cruelty to children. Now, records show the coaches have yet to retain an attorney, and they were both released on $75,000 bond. All right, still with me is criminal defense attorney Adam Johnson. And Adam, just a couple of quick points. The family has filed a civil suit against the school district and the school and the coaching staff, alleging that there is actually a ban in place in the county against practicing in extreme heat. So they say that. So you have that. And the attorney for the girls' family did say that now coaches will have to think twice about the level they are willing to push athletes to win. I'd love to get your thoughts on this. I'm wondering if this is the proper forum for this type of situation. I did a quick search and in the last month, there have been at least 4 different cases of football players dying under similar circumstances. They're starting their summer practices, and in Texas, Nebraska, Virginia, and Omaha, 4 players have died. What are your thoughts on this case?
It's a very difficult question. There's the fear that all sports will stop at a certain point if you're going to have criminal prosecutions of coaches, because you're placing children into situations where bad things can happen. Now, on the other hand, if there is a policy in place that was violated, that's important to the civil lawsuit. And it's also important, I think, within the context of the criminal prosecution, it's important to remember this is not a case that requires malice. The 2 principal elements of the state statutory offense require cruelty to a child, and so that has to be laid out, and a death that occurs. So not an intentional killing, not a malice murder, nothing of the sort. It's a unique statute, but it's an important question because I think the fear among many people is that, well, I'm not going to allow the kids to go out when it's 90 degrees because that's getting closer, 85. But society draws these lines. It's difficult sometimes to say where that line is, and maybe it was crossed here.
Now, with that child cruelty, what's required is that as criminal negligence to a child under 18 where severe physical pain is caused, and they say it was done here by that physical training. And apparently she showed some signs of distress and they still pushed her forward. Something coaches do all the time, hoping to push a kid through that pain threshold. But anyway, it's time now for our Talkback segment. Adam, I want to get some thoughts from our folks here. Each day we post a question on Court TV's social media pages. We gather the comments and questions of our audience and respond on the show. Today's question is, should coaches be charged with murder in the heat-related death of a student athlete? Now, our first comment is from Natasha Johnson, who says, the charge is wrong. To charge them with murder, the state would have to prove they intended to kill the child. They should have been charged with negligent homicide. I don't believe her death was their intention, but their actions did contribute to her death. And actually, Natasha and Adam, I'll go to you right after this. This doesn't require intent because it feels like a felony murder charge where if they can prove the underlying criminal negligence in causing severe physical pain to a child, then the death results from that. They have the murder.
Correct. That's exactly right. And perhaps some of these statutes should be renamed because we all think of an intentional, unjustified, or malice-oriented killing when we hear the words murder or second-degree murder in particular. But as you just pointed out, it does not require any such intention at all. In fact, that she could be, or the coaches could be convicted at trial beyond a reasonable doubt without any evidence that there was ever any notion of an intent to cause a death.
That's right. All right, our next comment comes from Melody Ella. In my opinion, it's inhumane to treat anyone, let alone children, like machines. Even a machine can get overheated. Difference is humans will die if pushed too hard, and machines can be rebuilt. Winning isn't worth the chances these coaches take. Charges are appropriate. And here's my only problem with that, and I agree with her 100% that sentiments that she is expressing. But at the end of the day, this is about the policy, right? We put so much pressure on coaches to win. If you want to change policy, I'm not sure charging the coaches criminally is the right way to go. They clearly didn't want to commit a crime here, didn't want to hurt a kid. They were doing what coaches have done forever. What you want to do is you want to sue the school district, sue the school to make them think twice about the way they approach sports in general.
Yeah, and I think historically you see evidence that we've been comfortable having these types of incidents play out in the civil arena, not necessarily the criminal arena. Again, the floodgates argument is there's the possibility that so many different actions taken by coaches, or bus drivers, school crossing guards, it's easy for that to bleed over into the criminal context potentially, or at least that's the argument that could be made.
All right. Well, Adam Johnson, I want to thank you so much for joining me this evening. Truly appreciate all your insights. Hopefully you'll come back and join us again. I'm Michael Ayala. It's been a pleasure being with you this evening as well. Coming up next in closing arguments, Vinnie Politan is going to take a look at the biggest moments of Robert Durst on the stand in the Jinx murder trial. He's also going to take you out to North Dakota as well for an update there. So don't go anywhere. Keep it right here on Court TV, your front row seat to justice.